Hey, everybody. Welcome to this week's Lawfare Live. We are going to give the webinar a moment to populate. I see nobody in it yet, so that is not a good sign. Anna, is that because nobody is in it or because it just hasn't populated yet?
I believe it's because it hasn't populated yet. We had 70 registrants.
Yeah, so, but none of them is here. Are we live on YouTube?
Mm-hmm. Yes.
Well, that's a matter of concern. Yeah, it says we're in a practice session. So I think we have not actually gone live.
Sorry, now we're all set.
All right, so now we are just going to let this populate. Apologies to everybody who's joining us on YouTube, and in this case, got an advanced look at behind the scenes Lawfare. We are going to be recording a conversation. As with last week, we don't know if it'll be a podcast or not. We don't really know what it's going to be. We will be taking your questions later in the conversation. If you have a question, please flag it for us in the Q&A. Please do not leave comments in the Q&A, because then I think they're questions and I bring you on and then you don't have a question. So use the Q&A to leave questions, to flag that you want to ask a question. If you want me to read the question, I'm happy to. We can also bring you on to ask it. In case this ends up turning out to be a podcast, let me start by saying I'm Benjamin Wittes, and this is the Lawfare Podcast, August 12th, 2023. It's been a week of news and events related to the Trump trials and tribulations, which is the name of this YouTube series. We are going to be gathering every Friday at 4 o'clock to chat through the week's news and tidbits and items that may not be worth individually a full Lawfare story, but are of interest. And I want to start this week with a phrase that I think many people had never heard before this week, but is now just quite the thing: the Garcia hearing. Quinta, what is a Garcia hearing, and why are we all talking about Garcia hearings as though we had known what they were? Like, everyone's authoritatively saying, well, we're going to need a Garcia hearing about that, as though they hadn't just learned what a Garcia hearing is. What's a Garcia hearing, and why are we talking about them?
Right. So the term Garcia hearing comes from a case, US v. Garcia. The idea is essentially that it is a way for a court to hold a hearing to inform a defendant of the potential problems that may result if the defendant moves forward with counsel who may have a conflict of interest in some way. The idea being that the court and the government can't force you not to have this person as your lawyer, but we want to make sure that you're fully aware of the potential risks. The government is concerned about this because they want to make sure that you're not going to raise this on appeal and screw up the whole case for them. The court, of course, cares about it insofar as it cares about the interests of justice. So we all are now experts on Garcia hearings because of something that happened in the Mar-a-Lago case. So Walt Nauta, who is the Trump body man aide who has been charged along with Trump in the Mar-a-Lago case, his lawyer is one Stanley Woodward. Woodward, according to a motion filed by the government, I believe has represented at least one other person who is referenced in the indictment, unnamed, not indicted, and is currently representing two people who may be witnesses at a trial. So you could see that could potentially come, you could create a conflict of interest if, for example, Woodward, in his role as defense counsel for Nauta, ends up having to cross-examine a witness who he is also representing. It creates sort of odd situations. So the government essentially files a motion saying, we'd like to hold a Garcia hearing. Normally, my understanding is that what would happen at this point is that you would wait for Woodward to weigh in and for him and Nauta to file a motion in response, and then we sort of decide how we want to handle things and move forward. Instead, what happened was that everyone's favorite judge in the Southern District of Florida, Eileen Cannon, sort of jumped in quite eagerly and created a somewhat odd situation. So she did a couple things, but the reason that we're talking about this is that there is some information in this government filing or filings that are associated with it on the docket where the government indicated that there was information that it could not file publicly because the information was secret. It was protected by rules of grand jury secrecy and related to a grand jury investigation that was ongoing. Presumably that is referring to the Washington, D.C. grand jury, the January 6th grand jury, which we know is still investigating. And Cannon's response was she denied the Justice Department's motion to seal this secret information. And she strikes the motion for leave to file under seal and the secret information from the docket. So for the purposes of everybody litigating this case, it's gone. And she asked that Nauta file a response brief to the Justice Department's motion, which, again, we probably would have seen anyway, but specifically says that he should file a motion that addresses, and I quote, the legal propriety of using an out-of-district grand jury proceeding to continue to investigate and or seek post-indictment hearings on matters pertinent to the instant indicted matter in this district. And she also essentially invites Trump and the other defendant in this case, Carlos de Oliveira, to file briefs as well, if they like. So the reason that this is strange, and I know this is getting a bit complicated, is that, and I'm drawing here on a great little essay by Adam Unikowski, that essentially she has asked people to weigh in on this matter of information provided by a grand jury that's still investigating, but she has struck that material from the docket. So she's created a situation where it's incredibly difficult to reference what the problem is. So that's just sort of a strange situation. And then it's also just odd because she's kind of leaping in when she doesn't necessarily need to. All she needed to do was wait and see what Woodward filed. She hasn't done that. She sort of leapt in advance, created this odd situation by striking the filings. And she's also saying to Trump, like, hey, do you want to weigh in? Do you have any thoughts? Kind of signaling to him, you know, if you want to step in, this might be a good opportunity. So everything that I've just described is quite convoluted. It also doesn't touch on the merits of the question of whether or not there's anything wrong with the government using a grand jury material that's from a grand jury that's still investigating another case, which is a separate question. But I think it's indicative of what a lot of people were alarmed about potentially when Judge Cannon was appointed to this case, that she has a tendency to kind of jump in, shake things up a little, maybe not in ways that make a particularly large amount of sense, and also in ways that may give an advantage to Trump that he wouldn't have had otherwise.
Yeah, so let's, I'm curious whether anybody wants to make a defense of this action by Judge Cannon. I cannot honestly see how it makes sense. It seems to me that without knowing whether the out-of-district grand jury is investigating what it's investigating, you couldn't possibly know that there was a propriety problem with it, right? Maybe it's investigating acts that took place in Washington or in, as Scott would point out, in Bedminster, New Jersey. Maybe it is working on a related matter that is not the same matter that was indicted in South Florida. And so I'm curious whether this makes more sense to anybody than it appears to Quinta, or then, let me put it, lay the matter bare than it does to me.
So I'm not ready to defend it. In fact, I think I was probably more critical of this than Quinta was when we talked about it on episode of Rational Security earlier this week. But I will say this, I think the decision to say we're not going to dig into this other universe of information, again, these sealed documents that appear to be other grand jury information until we resolve the prior issue that it's proper to look at other grand jury information itself isn't fundamentally unreasonable. Again, I think you're probably right. There are lots of reasons why that's totally appropriate, and jumping to the conclusion that it's not isn't appropriate. But you could see a reasonable argument to say, okay, let's have briefing on whether we even should consider this evidence before we start introducing it and putting it on the docket, and then talking about whether we accept it under seal. And then, of course, you do want briefing on whether a Garcia hearing is necessary or appropriate. It's not unusual to see that. It is weird for her to jump the gun and ask this question. And it is weird. If we saw a judge who wasn't Eileen Cannon do this, I think we would just say, that's weird. And just say, but trial judges are weird. They get a lot of discretion how they run their cases. Some are a little more eager than others. It's not fundamentally weird. Here, it's against this backdrop of Eileen Cannon having done other weird things that seem to favor former President Trump earlier in the litigation matter. So I don't know. I will say I read a good part of the transcript of some of the hearings they had this week. And I actually thought the judge came off relatively even-handed and in how she managed that, which was kind of interesting. So I wonder also if sometimes there's a docket speech issue, like judges use the docket in different ways and sometimes have trouble communicating things effectively on the docket than in other contexts. And it's possibly Judge Cannon has that. So I'm not ready to condemn anyone yet. I don't think it's easy to explain this as totally normal, but I also don't know if it's reason to assume that she is just in the can for Donald Trump already, despite her priors.
All right. So do we and how are things currently situated in South Florida? Quinta, I take it this issue has not been fully briefed yet, and we still don't have a protective order, right?
That is my understanding. I confess I did not have time to check Pacer before we started. I see Scott is nodding, but it's also
a couple hours ago.
Okay. It's also worth noting that Judge Cannon, unlike Judge Chutkin in DC, who I'm sure we're about to discuss, has not exactly been moving at rocket speed. So it does not surprise me that this issue is still kind of left hanging.
Right. So by contrast, Sarafin Dhanani, who is joining us on Lawfare Live, I think for the first time. Is that right?
That is right.
Right. So Sarafin, you were in court today when Judge Tanya Chutkin of the District of Columbia considered the matter of the protective order, which she then, you walked out of court and she issued and threw at you as you were walking away. Let's walk through what happened in court today. This is now in the January 6th case in Washington. Give us a little overview.
So I'll begin by saying this. I thought Quinta's point was interesting towards the end. I actually don't know if it's right for us to conclude that Judge Chutkin is working at rocket speed or breakneck speed. After the hearing, I think there was a sentiment shared among folks in the media room that she's quite fair and she's not doing anything that's unusual. She's not trying to push this case along for, ulterior motives. It's actually within keeping of her responsibilities. And she made that very clear at the hearing. So this case is about, or this hearing was about the protective order. And essentially it's being argued right now because there is a dispute between defense counsel and prosecutors about the scope of the order. So if, for those of you who watched the Sunday talk shows, you'll know that John Lauro, who is Trump's attorney, went on television and shared that the prosecutor's protective order proposal is just too broad. They are both trying to limit Trump's access and dissemination of not only sensitive information, which would make sense, but also non-sensitive information that comes out of discovery. And what they're asking for is a limitation on just the sensitive information. And Judge Chutkin called prosecutors up and asked them very explicitly, what is the good cause? What are you showing here that would convince me that you need both sensitive and non-sensitive information? And they laid out three arguments. The first, they said, is they're trying to protect witnesses, both witness reputational harm that could occur and also any sort of threats or intimidation that witnesses would face if any documents were leaked to the public. The second, and it's similar, which is that they're trying to protect the jury from any sort of pollution. Having received some of this information from Trump or from his defense attorneys, it could sully their perception of the case and their, responsibilities as the jury. And then the third, and this harkens back to Laura's appearance on television, which is the concern that this case is being litigated in the court of public opinion and it's not being litigated in the court of law. And to prevent that and to keep it within the bounds of the court of law, the government wants to have a broader definition of what would be encapsulated within this protective order. And Judge Chutkin pushed back because in her mind, she wondered, why can't you just take this information, all of these materials, and disaggregate them? Some of them are sensitive and some of them won't be sensitive. That seems like a very reasonable thing. And prosecutors really reinforce this point that we just can't trust Trump. He has already said explicitly.
And how explicitly did they say that? Like that, I'm sorry, Judge Chutkin, we're dealing with a defendant who sucks and who goes out and attacks people and, ruins their lives. And we have a bunch of witnesses we want to protect from Donald Trump. How explicit was that versus, expressing concerns in general in, that kind of people knew what they meant?
Pretty explicit. At one point, the prosecutor mentioned that they are trying to protect these documents because he said something along the lines of Trump doesn't have the best track record when it comes to these sorts of, sensitive, non-sensitive information. He was referring to the Mar-a-Lago case and referring to the documents, I think, that Trump took with him from the White House. And in fact, Laura also got on the stand and, to the podium and mentioned when Judge Chutkin talked about, witness protection and the fact that some witnesses might feel intimidated if Trump were to berate them publicly or release sensitive information. He said explicitly, are you referring to Mike Pence? So I think that was always clear. There was an undertone of that. We all know that, at least the court knew, that there is a tendency by the defendant to use some of this material as ammo. And there was a concern among prosecutors that whether it's sensitive information or non-sensitive information, it should be kept out of the public's view. And Judge Chutkin actually agreed in part with the defendants. When Laura was the only one who spoke on behalf of the Trump team, the Trump defense, Todd Blanche was there, but he sat at the defense counsel table and didn't say anything during the course of the—
Did he whisper a lot with Trump? Because Anna Bauer's account of him in prior hearings is that he seems to be the lawyer whose job it is to manage the client, and that the client really seems to talk to him, but he's often not the guy who's making the arguments. Is that consistent with what happened today?
Trump was not there, but—
Right, I forgot about that.
Yes, but what I found really interesting about Blanche is he laughed a lot. I mean, Judge Chutkin has a personality. She had no problem giving a side eye, rolling her eyes, chuckling at many points, making jokes. I mean, I really think her personality came through at this hearing, and he laughed along with her. I mean, he was very, very amicable. Whenever prosecutors came in, he shook hands with them. He whispered something to one of the prosecutors. I mean, he was quite friendly, if I could say that. And I think Laura's job, if I understand this correctly, and I think he's the PR guy. And I say that because when he went up to the podium, his arguments echoed a lot of what he talked about on Sunday's talk show, which surprised me quite a bit. He mentioned that the Biden administration will have an unfair advantage if the court were to allow the protective order from prosecutors to go through. He mentioned that if Trump were to inadvertently reveal information over the course of a debate, which can get heated, it would both raise a red flag and it would put Donald Trump under a microscope, and that's just unfair. And that in turn would limit the First Amendment right of the former president. And so for all of those reasons, Judge Chutkin came down with the decision that the defense counsel's proposed order would go through. She granted it in part and denied it in part, but and she made very clear that she's not making this decision out of a concern for the campaign, out of a concern for fairness in the campaign. That is not her job. Her concern is just to ensure that there is a proper adjudication in this case and that witnesses are protected and the jury pool is not sullied and that whatever is sensitive remains within closed doors and whatever isn't, that can be debated effectively.
So then a couple hours after the hearing ended, she then issues an order. What did the defense get? What did the prosecution get in that order?
Well, it's interesting. So there were two parts of the order. So obviously defense got the sensitive information. So now the protective order only safeguards sensitive information. Non-sensitive information is not included. That we know. So the 2 points that I thought were really interesting that the defense counsel raised. The first one, they wanted to expand the scope of what is included in the term employees of, I'm saying this roughly, but who counts as an employee of the defense counsel? Who are those personnel that have access to discovery? And they were trying to broaden the scope and say, well, we should be able to hire volunteer attorneys. We should be able to hire consultants. Like, let's have them have access to this information because we just don't have the manpower that the prosecutors do to properly triage through all of these documents that we're receiving in discovery. And Judge Chutkin actually said something that was quite striking and cutting. And it was the first time that it took, I think, John Lauro aback. And she said, counsel, we can't do that because what if within that definition of personnel, you include someone who is a co-conspirator who has not yet been indicted? And he pushed back, obviously, but not without pausing and sort of taking that question in. And then as we see in the protective order, she didn't expand the scope of that language. She also made a joke and said, you know, I live in Washington, D.C., everybody is a consultant. So, you know, conceivably anyone could have access to this information. And that got quite a bit of a chuckle from the crowd, including Todd Blanche. And then the second thing that the defense counsel was trying to push was how to handle Trump's access to this information. So initially, the way the protective order was written by prosecutors roughly was that prosecutors wanted defense counsel to be in the room when Trump is looking at these documents. And if he takes any sort of notes, that defense counsel should look at those notes, make sure there's no identifying information in them, and that he doesn't walk out with that. And essentially what defense counsel said is that that's taking up a lot of our labor. You know, we're already a slim staff. You're expecting us to then babysit, and that's the word they use, babysit the president. That's very unreasonable. And so the resolution that Judge Chutkin came to was, okay, fine. So you don't have to babysit him. You can give him discovery and let him evaluate it on his own. It has to be, there has to be oversight. So even if the counsel is not sitting in front of former President Trump, they have to be able to be available to receive discovery when he's completed looking at it. There can't be any electronic devices that are in the rooms because there's a risk that he could take pictures, he could somehow photocopy some of the material. So she nixed that possibility. And of course, if he takes any notes, counsel has to evaluate those notes and scrape away any identifying information. So that, I thought, again, was a middle ground that she reached with both sides. And I think that's really the tune that she's singing. I think she wants to make sure that she's being fair. And so this idea that she's working in breakneck speed or she's doing something that's unusual because she wants to see this trial go through. It's true that she wants a speedy trial, but she reinforced again and again that this is in the interest of justice. And I know, at least among media personnel, that was quite convincing.
So a couple things. First, Seraphin, look at the chat. There's an administrative matter you need to take care of. So a couple things. One of the explanations may just be that she's a much more experienced judge than Judge canon. She has sat on January 6th cases before. She's had a lot of criminal litigation in front of her before, including on some issues that overlap this one. And she hasn't been on the bench for, an hour and a half. So, what people are attributing to either her being particularly fast or Judge Cannon being slow may be a function more of experience than anything else.
I will just to interject very quickly on that. I think the fact that she has ruled as fast as she has, including on a Saturday morning, is an indication that she is moving notably fast. I think it is entirely fair and Seraphine's right to raise that shouldn't be read into in the sense of indicating a preference or a lack of fairness toward the parties. But I think it is certainly the case that, statistically, she is moving very fast.
I mean, speed in a judge is a virtue as long as it doesn't come at the expense of anything else. One of the most frustrating things I have ever seen as a reporter and covering this court, I'm going to not name names, is a judge who sat on a case for 23 years. And that was an unbelievable, that's not an exaggeration, by the way. It was an unbelievable disservice to the parties in question. And so anytime you can get a ruling that is as good as X, but you can do X in 2 days or 1 day or 2 hours, that's a good thing. And so speed is generally, speed is a virtue. All right, let's move on to the next issue. Oh, wait, before we move on, Seraphine, did anything else come up in the hearing? Were there any other issues discussed?
I don't know if there were many issues that were discussed, many that I can get into. I think
Tick them off, list them. What did they talk about?
Well, one thing that I do want to reinforce here is the reliance that the defense counsel had on this idea that this is some sort of political operation by the Biden administration. At one point, Lauro made a comment that this is a contempt trap, to which Judge Chutkin chimed in and said, that is just not true, counsel. This is not a contempt trap. This is a criminal defendant.
What did he mean by contempt trap? I mean, that's not actually a phrase that I've heard a lot. I've heard of perjury traps, but what's a contempt trap?
Your guess is as good as mine. The context that he gave was that, again, this is a political trial. We're holding Trump under a microscope, and it's going to affect his First Amendment rights. And the thing that Judge Chutkin said that kind of caught his attention is, and she also hesitated to say this, which is, look, I understand this is his quote day job, but he's also a criminal defendant. And so we have to apply the rules that we would to a criminal defendant. And she reinforced that again during the hearing, which I do think took several people aback, because it was very explicit that we aren't just dealing with a presidential candidate, Donald Trump, we are dealing with a criminal defendant.
All right. Can I throw out a theory of what a contempt trap is, and then you tell me if it's consistent with what was going on in the hearing?
Sure.
It seems to me what Lauro is trying to get to is you have a whole lot of different rules that are put down in protective orders, put down in pretrial release conditions, that are things that maybe a normal criminal defendant who doesn't run for president and doesn't like to attack people can comply with, but that are just unreasonable to expect Donald Trump to comply with because, he holds rallies and attacks prosecutors and judges and witnesses. And so you're issuing these orders knowing that he's going to violate them with the idea that he's then going to be held in contempt, which all seems to me perfectly reasonable if it's a reasonable order. But is that sort of what he was getting to?
I think that's right. It's hard because then if what you're saying is true, which actually that does sound right, then the comments that he made thereafter, that Trump will abide by this order, you don't have to worry, undercuts that. And so Judge Chutkin also reinforced that he's also bound by the pretrial release condition. And so this concern that prosecutors have that he's going to intimidate witnesses, that's all captured within the pretrial release conditions, even if it's not captured here in the protective order. To, I think, mollify Lauro, who, to your point, is concerned by this contempt trap. Although then he continues and says that Donald Trump is going to abide by everything. So yeah, I think it's a little bit of everything.
All right. Anything else happened at the hearing that we should know about?
Not at this moment. I think that was the highlight.
Well, excellent answer. Note that she said not at this moment, meaning that she's not committing herself to not interjecting later that, oh, I forgot
She's
about.
a good lawyer.
Yeah, exactly. All right. Natalie Orpett, we have some trial dates, real and tentative. We have some trial dates proposed. And it seems like Donald Trump is going to have a busy 2024. So first of all, give us an overview of what we know about which trials are happening when and which trials are proposed for when. And then I want to drill down a little bit on whether this is actually feasible.
Sorry. Okay, so I'm going to try to remember everything, but let us first set the stage with the fact that Trump is subject to even more cases than we've already talked about right now, which is that there is a criminal trial in New York State Court currently scheduled for, does anyone remember offhand? I'll find it.
I don't know the date. It's in March.
Yeah,
March.
it's in March.
March 25th, I think. There are two civil trials also in New York, one brought by the Attorney General of New York, one a private claim scheduled for this fall. The Mar-a-Lago case is currently scheduled for May. And of course, we do not have a trial date scheduled yet in the DC case, although today the government filed a request. I believe that filing was today.
I think it was yesterday.
Was it yesterday? Okay.
Yeah.
Time blurs
requesting. Together. It really does blur together. The requested trial date from the government's point on for the January 6th case is December 2nd. As a side note, I was very bemused by the fact that in the government's request, it noted that
Wasn't
it wanted
January
to have
2nd?
Sorry, what did I say?
You said December, I think.
Sorry, that's because I was about to make this next point, which was that I was bemused by in the brief, the government asked for jury selection in December, but not starting the trial, no matter how long jury selection took, until January, so as to respect the holiday plans of the jurors, which I just thought was very sweet. I want to emphasize, because I think it's something that is not getting enough talk right now, the notion that, as I'm sure most people watching this already know, there is a lot that happens before you get to trial. And so there are a lot of interim deadlines in all of these cases, and they will all be happening at the same time. So the logistical challenge of scheduling is certainly one thing, but that starts before trial. Trial is the most difficult because there are lots of days in a row where you spend the entire day in court. But every case has in between a lot of pretrial activities that require pretrial motions, that require scheduling issues, where there are deadlines in place that are going to overlap between the different proceedings. So we can dig into that a little bit more.
What's the worst example of that you can think of?
I mean, I think part of the difficulty right now is that We don't have the scheduling order for everything. Another part of the difficulty is that scheduling orders almost invariably change as litigation develops, although judges will try very hard to stick with them. I wrote a piece recently for us where one example that I don't think at all is the worst, but is a useful illustration, is that the trial in New York is scheduled to start March 25th. I believe that's the right day. It's certainly late March. And in the Mar-a-Lago case, at the end of April is due the Trump team's motion it's a response to the government's motion regarding the use of classified evidence at trial, and specifically the substitutions that the government would like to make for classified information that it does not want to have to show the jury. So that sounds like a very weedy example, but that's the proceeding in the Mar-a-Lago case is part of CIPA, the Classified Information Procedures Act. And it's a really, really crucial pretrial moment because it's defining what the jury is going to see. And inevitably, the government is going to ask for more substitutions and more restrictions on what information the jury is going to see than the Trump team is going to want to have be the case. So they're going to need to respond to that motion. They're not going to know what they're responding to until the government files its motion, which is, I believe, around the same time as the New York trial is starting. And in order to prepare a CIPA response, you are almost certainly going to have to spend a lot of quality time in a SCIF. That's the secure facility where you can review classified documents. You're going to physically have to be in a SCIF, reviewing the documents, reviewing the proposed substitutions, and formulating your arguments as to whether they're sufficient, all while the same team of people is supposed to be sitting in court in New York State.
Right. So, all right. So let's, I'm going to draw on your experience as a big firm lawyer here. Natalie used to work for the law firm of Jenner and Block. And I know how Jenner and Block would handle this situation, right? Jenner and Block has buildings full of lawyers, and they just deploy as many of them as they need to. So you need more lawyers doing CIPA review, you get more lawyers with security clearances, and you send them out to the SCIF. And you do that while the trial team is handling the New York trial or the January 6th trial but if you're Donald Trump right now and you're not represented by a big firm, you've got Todd Blanche, you've got our new favorite Tampa lawyer, Mr. Lauro, who, by the way, I think did a terrific job, by the way, on the Sunday talk shows. Seraphin and I have been spending some time with the arguments that he made, and I think he actually did a really good job, and he put forward a pretty interesting set of defenses for the former president. So I'm not throwing shade at any of them, but as best as I can tell, that's two guys, right? And they probably have some associates, but you're not talking about a giant trial team the size of you can just add people to or remove people from as you do it. How do you do this just logistically? Do you just hire more lawyers? At some point you run into there's no way to responsibly defend all these cases at the same time problem.
I agree. And I think that's one of the reasons I really wanted to draw attention to this stage of things, because sure, there's a lot to worry about at the trial, but there is a lot to worry about before getting to trial. And most likely the very problem that you're identifying is going to come up in fact, I will say it will come up in a way where there will start to be very compelling arguments that the quality of Trump's defense in any one of these cases is being compromised by his responsibilities to the other cases. And that's going to start moving the schedule, and that's going to start delaying the trials. And that just means that these trial dates that have been set right now, we really can't rely on, because there are going to be legitimate arguments that he can't prepare a proper defense without the sufficient resources. I think in answer to your question, yes, they will need to have more than 2 attorneys. There's no way around that. It is notable that, I mean, sure, they, as far as I understand it, don't belong to a large law firm where they have a lot of people sort of already in place who could be deployed. But I mean, we do know that Trump has a lot of resources. We know actually that he has requested money back from his PAC to pay for legal fees. I don't know how many lawyers he is intending to hire and where they're planning to get the manpower from. But I will say, having been someone who was in charge of the sort of air traffic control of trial work and running teams, the sheer logistics of managing a lot of attorneys is not nothing. And bringing on and getting up to speed a lot of new attorneys who, sure, they've been following the news, but they haven't seen any of the filings. Certainly no one's yet looked at discovery, but this stuff doesn't happen immediately. It doesn't even happen overnight. So it's a genuine problem.
Yeah, I think it really is. I mean, it's going to be an increasingly important problem, and I don't know of another case like it. I know of cases where you have, indigent defendants or defendants who can't afford to just hire more lawyers, who are kind of overwhelmed by, but I'm not sure I've ever seen a case where you have, because of multiple complex litigations filed essentially all at the same time, a well-resourced defendant defended as thinly as Trump is here. Usually it's like, I don't know, Purdue Pharma just brings in as many lawyers as they need, right? And when you do that, when you're defended this thinly, it raises questions about the sustainability of a conviction on appeal. It also raises questions that I don't know the answer to. Can one of these judges just point at him and say, dude, you need to hire more lawyers, right? Or are you waiving the right to do it by not doing it? I just don't know I'm not sure I've ever seen a case where a better resourced defendant is both a combination of choosing to have so few lawyers, but also can't hire first-rate lawyers because he's known to A, not pay them, and B, known to not be a manageable client. I think it's going to be a super big deal as we pursue this.
There's also, if I can say one thing, I think there's a question of how much Trump will be able to pay when it comes to legal representation. So we know from the New York Times that Trump has basically been using money from a super PAC, so from donations to fund his legal fees. It's, I believe, over 27 million in legal fees and related bills so far. I think that's for both Trump and sort of others in his orbit to whom he's helping provide legal representation. But the Times reported today that they may be burning through that cash at a pretty unsustainable clip. And so the question is then whether Trump will be open to spending his own money to pay for lawyers, how much money he actually has to pay for lawyers, which goes to the question of how much money Trump has, which is a famously uncertain issue. So I could definitely see that kind of potential cash crunch colliding with the dynamics that you described, Ben.
Yeah, so somebody just texted me who will remain nameless. I wonder how many lawyers John Gotti had, but that is exactly my point, because John Gotti had, one giant case that does not involve major production of classified information. He didn't have 4 concurrent cases in 4 different jurisdictions with complex discovery issues of different types in each of them. And I am sure that John Gotti had all the representation he needed for that case. So I don't know. I've never seen anything like it, and I'm not sure that I'm not sure that's not because there hasn't been ever been anything like it before. All right.
I mean, I'll just on the theme that we have talked about a lot about how Trump should be treated like any other defendant. I mean, defendants who are given public defenders would be able to successfully raise this defense all the time, not because public defenders are not excellent lawyers, but because public defenders are severely strained and under-resourced and have just absolutely ridiculous caseloads. So, in the event that Trump is not able to pay for more lawyers and he is running a very lean team, they're going to file motions saying that they are not able to meet these deadlines, explaining that they are pulled in a million directions because of these other proceedings. And it's going to be up to the judge in each matter to decide whether that's compelling.
Right. And I think each judge will then have to answer the question, do you treat that like a request from an indigent defendant, or do you say, sell Bedminster and buy and hire some more lawyers? You're not without options here, right? And I just don't think that's a situation that we've confronted very often. All right, Mr. Scott R. Anderson, let's talk about classified information at Mar-a-Lago. I want to start with the really important question. In the past, when people have been indicted for mishandling information at their golf clubs, mishandling classified information, have they requested that the government build them a SCIF so that they can review the classified discovery in the same facility in which they committed the crime? In other words, have they filed motions that said, please let us commit this crime again?
He's actually only asking that they rebuild the SCIF that was previously there. So it's a little different than you've alleged in this particular sequence of facts.
Not very different.
Not super different. It is a little different. We've seen an interesting exchange around the protective order. There's a very similar debate that was resolved more or less this week, apparently, within the DC District Court around the prosecution there. We've seen drag out for the past 2 weeks or so. I think it was March 27th or 28th that the government filed its initial proposed protective order, governing the same questions about how do we handle this if discovery we're going to provide to the defense team for Trump and Nauda, and now their third co-conspirator defendant as well. How are they going to handle these documents and sharing with them? Much more complicated in the Florida context, because unlike the DC context where there is a small amount of classified information and they appear to be having a separate process on that because they're having a separate CIPA briefing stream that I don't believe is resolved today, although Seraphine, correct me if I'm wrong on that. The Florida focus has been... Oh, sorry,
I
go ahead.
believe it's, you're asking for the date, is that right?
No, I was just saying, I don't believe they resolved the CIPA issue yet. I think it was just filed today or yesterday,
Yeah,
right?
I don't think so. But if I have this correctly, I think they also set a date of August 28th to discuss the matter.
Okay, interesting. So it's a few weeks out on the CIPA matter as well. Here in Florida, we've seen for a little over 2 weeks now, or about 2 weeks, this debate going on over a similar protective order in Florida. Much more complicated, though, because it involves a ton of classified information. Unlike the DC prosecution, a lot of particularly former President Trump's criminal charges in the Florida indictment center on substantive classified information that need to be substantively reviewed by the defendants, or at least have some knowledge of the content for them to be able to launch a defense. So there's been this back and forth about how do we manage this. The government essentially brought forward a proposed order that says, hey, look, we're going to keep the classified information. We're going to keep it at a government facility. We're going to give you clear defense counsel access to it. And then you're going to have to discuss this to the extent it's necessary in a classified facility. And that is pretty consistent with government handling standards. Basically, you're not supposed to talk about classified information outside of a classified space, particularly when it's classified at a certain level. I'm not supposed to just go out on the street and start talking about this stuff. You're supposed to keep it in classified zones, essentially. That is not the position that former President Trump or Walt Nauda, who both filed briefs opposing this, have come forward with. And they're both very interesting briefs reflecting kind of different tacks, to say the least. We haven't seen Mr. Oliveira actually file on this, I don't believe yet. So we may see a third one yet forthcoming. Presumably the same order would be as relevant to him as it is to Nauda. The former President Trump came forward and asked for something along the lines of what Ben suggested, basically saying, look, you had a SCIF at Mar-a-Lago for many, many years, that in which we held classified information all the time. Let's restart up that SCIF. Now, notably, they're actually not asking for, as it was originally relayed in some Twitter accounts and press accounts, asking for former President Trump to be able to hold classified documents there. They're hoping to restart this SCIF at Mar-a-Lago for the purpose of being able to discuss this matter with Trump, so that they can sit down and have meetings discussing about the legal position, discussing some of the content of these documents without having to go and have those conversations in a secure facility offsite. That is a more limited request, but also not necessarily entirely dissimilar, as Ben's somewhat sarcastic take on it relayed. I believe Brandon Van Grack, one of our contributing editors, described as kind of re-victimizing the Justice Department, which is a dramatic but not inaccurate way of relaying what's happening. You're going back to the state of...
it's real chutzpah.
It is ballsy.
Saying like, it's like you're alleged to have stolen material and put it in a cave, and you ask for the discovery to be delivered to the cave.
I agree. Now, but it's also, frankly, like a little bit of a strategy point for them, because they're in this briefing, they're essentially acknowledging that the place we had before was not up to the security standards of a SCIF, because they're basically saying, hey, look, we're going to restore all these measures we had before. Not when we were holding all these classified documents there, before that, that we had when we used to review these things. So it's not entirely risk-free, to say the least there. But it is an argued brief. It's not, from my view, from the perspective of an advocate advocating for his client. And you can understand why former President Trump would want something like this, because he's going to be running for office and things like that. And signing up to go to a secure government-run facility to have these conversations is going to be hard, given the volume of material and the 32 charges that, again, center on this substantive information. So it's a totally reasonable brief, I thought, in terms of tone, substantive content. It wasn't kind of blustery and kind of nonsense. Very different from Walt Nauda's brief on this issue, which opens with a very dramatic quoting of a quote from the wall at the Justice Department, and then proceeds to kind of wax poetically for like 8 pages about the importance of criminal defense to be able to launch a defense, and then basically says essentially, hey, the government, all the government is saying is that this is going to threaten national security. They say nothing specific about that. Note, it's really hard to say how disclosing classified information will threaten national security without disclosing that classified information, because that's why it's classified, right? That's the whole point. So it's not surprising that the government can't come in and give very specific reasons about why disclosing this classified information will threaten national security. But Nauda's brief, which notably was written by his Florida counsel, not by his DC counsel, Stanley Woodward, one of the late covers, Dadan, I think is the last name of the Florida counsel, as I recall. They essentially argue that those kind of generalized U.S. national security interests cannot weigh against the individualized interest of Walt Nauda in launching his defense, and reject the proposal put forward by the government without really making any sort of counter proposal. I guess their proposal is that there be no protective order. It's an interesting brief. I think it makes more sense in the context of, for Walt Nauda, this doesn't really matter that much, because again, most of the criminal charges against him don't hinge on they hinge on the fact of classification. They don't hinge on the content of the classification. I'm sure they will make some effort to get this stuff for gray mail purposes, for the purposes of trying to make it harder for the government to bring this prosecution. But the truth is, the substance of this information doesn't really matter for him, could matter a lot more for former President Trump. And so my suspicion is that this is kind of a broad attack written fairly quickly, without a real serious targeted effort to get any sort of gray area. They're just kind of trying to preserve the issues and throw a bunch of things against the wall, thinking something might stick. And the fact that it was, again, written by the local attorney who was brought on very late in the game, not for Nauda's kind of chief legal representative, Stan Woodward, I think probably supports that conclusion.
And Scott, I look at the question of how Judge Cannon handles a protective order as a kind of early test for her. It's a disputed issue between the parties. There are within certain parameters reasonable answers. There's a limited set of reasonable answers. You're not going to build a SCIF at Mar-a-Lago or rebuild the SCIF at Mar-a-Lago for the president's convenience. You're not going to allow him to review classified information. Maybe not at all. He's not entitled to see it anymore. But you're certainly not allowed to going to allow him to. You're not going to allow it to exist in a non-secure environment. And so I do think like you're going to see how far outside the lines she's going to be willing to draw here, right? And we're going to learn that pretty soon.
So I'm not sure I actually 100% agree with that, because I don't think Trump's request is so far wildly beyond the lines if it's actually limited for the purpose of discussing the legal defense. They could have made a much bolder request, right? We saw that around the scheduling request. It was very bold to say, let's not have this trial till after the presidential election. That is a grand.
How about never? Does never work for
or never?
you?
Exactly. That's really the goal, hopefully, right? Post pardon and everything. So that's the big swing. This is not a big swing. Like, you could have envisioned a much bolder set of requests, even without going to the far extreme that Nauta did. The government, or that Trump and his defense attorneys would have made. This strikes me as much more modest than that. Doesn't mean I think it's necessarily the right approach, but even if the government were to give into that, given the equities of criminal defendant and the unique nature of this defendant, presidential campaign, things like that, I wouldn't be shocked, and I don't know if that would drive me to immediately panic. That said, I'm maybe more generous to Judge Cannon on these things than many other people are. I'm sure many people will read that as a sign that she is in fact in the can for former President Trump. It is a unusual request, to say the least, but it is an unusual situation. And is it one that strikes me as so far beyond reality to be unreasonable to even consider? I'm not sure I'm quite there on that. But that's me. Other people, I'm sure, feel differently.
All right, we are going to go to audience questions shortly, but I have one more question for Scott before we do. We have that rare thing happened this week, the release of a law review article that actually merits discussion on Lawfare. As listeners may know, I hate the law review form with all the fire of 1,000 burning suns. I think very few law review articles are worth anything. But this week, 2 law professors issued what I think is a genuinely important piece of scholarship on Section 3 of the 14th Amendment. And so my question to you, Scott, is what is it? And is Donald Trump going to be barred from being on the ballot as a result of it?
Yeah, it's a really interesting development. It's worth giving some context about how this came about. So the article is by 2 pretty well-known conservative legal scholars, William Bode, who is kind of a young, not that young anymore, I think he's only a few years older than I am, but young-ish, up-and-coming legal scholar who I think has established himself as kind of a shining light of the kind of the new generation of conservative legal scholars, and somebody who is seen as kind of respected on all sides, as they say at times. I actually
deeply respect. I mean, like, everybody,
he's a substantive guy. Yeah,
everybody loves Will Bode, and he's Chicago's kind of golden constitutional law guy.
I think that's probably a fair way to put it. Yeah, and it's worth noting in a kind of originalist camp, in a kind of like I can't remember whether he clerked for Thomas or not, but I know
he clerked for the chief.
He clerked. That's right. Yeah, that's right. But yeah, I know
I met him when he was clerking for the chief.
I see. He in a lot of his writings, he channels a kind of vision of originalism that leans into some more unorthodox views and conclusions from that in a way that Justice Thomas does. So standing doctrine, something that I know for him from his writings on, I've read some of his articles about him and Thomas. He does a lot to bolster Thomas's fairly unique take on standing doctrine, which actually aligns more with liberals on the court in outcome, even though it's rooted in kind of originalist principles. And I would say Michael Paulson, very much a similar vein, very deeply conservative, principle guy, but firmly in the originalist camp, both of which they've been contributors on a ton of things over the years. I think like 2 or 3 books and case books. I think a few other law review articles, if I recall correctly. And they're both pretty well-known figures kind of in the conservative movement.
And Will is one of the co-hosts of what I think is the best Supreme Court podcast out there, which is Divided Argument.
That's right. Yes.
With Dan Epps. And it's a great resource for people who want to follow the Supreme Court with a nerdy kind of neurotic nerdiness that other podcasts won't do.
but a limited commitment to regular release because it doesn't come out that often. If you're willing to roll the dice on that combination, by all means, it's a great podcast. But I do enjoy it. It's a great listen. They published an article which essentially looks deep into the history of Section 3 of the 14th Amendment. This is a provision that we've heard a lot about, seen a fair amount of litigation around the last few years, not related to Trump, related to other people tied up in January 6th. That essentially says people who engage in insurrection may be disqualified from holding public office, at least barring action by supermajority of Congress to provide some sort of amnesty to them. To put it in extremely shorthand, read Section 3 yourself. You'll see what I'm talking about. And there's ongoing debate saying, well, how extant is this restriction in practice? The Supreme Court has never really dealt with it. Frankly, has very limited case law around it. Congress did a lot with it immediately after the Civil War. It came up in some internal congressional debates in the early turn of the last century, right after the turn of the last century. Hasn't really been talked about much since or come up in a lot of other contexts. And so there's a longstanding debate saying, well, to what extent is it still operational? Would it apply to this scenario? Meaning there's some laws that Congress might arguably pass saying that might have limited it or restrained it. So do those apply? Have those removed as effect? And then if it is operational as a constitutional matter, what do you do to actually implement it? Because the actual section is fairly quiet about what you have to do to implement it. And there's at least one court case, Griffin's case, that suggests that it is not self-executing, it has to be implemented by somebody. And then the question is, well, who's going to implement it? Republican House. So Congress probably isn't going to. Majority Republican nominated Supreme Court, they may not. Who actually is responsible for this thing? And they argue in this article that Section 3 is self-executing and applies very clearly to this content and is in fact quite broad in sweep and scope in a way that might surprise some people in some ways. It is a really deeply researched and written article. I haven't read all of it because it's 120 pages single spaced, and I think it just came out yesterday. So I've skimmed it and look forward to reading the whole thing over the course of the weekend. It's a really interesting read, and what's notable about it is that it's coming from these two really well-respected conservative guys. A third fairly well-known, very well-known, and widely respected on certainly among conservatives, legal scholar Stephen Calabrese came out with a post on the Volokh conspiracy, a widely read libertarian/conservative legal blog, basically saying the exact same thing, maybe like an hour before this article posted, for reasons I'm not entirely sure, but seems very it doesn't seem like it'd be a weird coincidence. I'm assuming they were somehow coordinating and knew they were going to make this effort and have all come forward making this statement. Calabrese notably is one of the founders of the Federalist Society, although he's had a bit of a tiff with them over the last few years during the Trump years. But another one of these figures who's been probably one of the most notable conservative legal academics of the last 3 decades, by name and by reputation, and in terms of his organizational involvement with the Federalist Society. So the fact that these 3 people coming out making very similar statements and then having it backed up by this deeply researched law review article that is going to come out in the University of Pennsylvania, but it won't matter, law review, but it won't matter by then because it's already on SSRN and everyone's just going to read that version. It's really a notable effect that people think this might actually matter. These are the sorts of views that will sway people in conservative, legal circles. I have no doubt that's true. Like, this does a lot to legitimate this argument with that particular audience. I am far less convinced this actually is going to sway any institutional outcomes in a way that matters. I remain highly skeptical that this will end up mattering at all, or that this is a way that any institutional arrangement could let this issue be resolved about former President Trump's eligibility for office. But it's a really notable event, and notably Bowd, Paulson, and Calabrese, or at least Bowd and Paulson, seem to have anticipated, they knew them saying this would have this effect, because they almost immediately had an article published with Adam Liptak of the New York Times, in which they'd given an interview, obviously pre-written before they released this. They had a kind of a coordinated media front in releasing this article. And in that way, it's kind of interesting, because it's a conscious effort to say, not only are we producing scholarship, but we are truly trying to be the kind of scholar statesman, releasing scholarship with an eye towards it having this public impact, and then doing the things necessary to amplify that impact. And we'll have to see where it goes. I think
those things, except for writing a version of the article on Lawfare. And
despite our best efforts.
And I just want to point out to you all that is really bad practice when you write the genuinely important law review article. It is your patriotic duty to get in touch with us and do a version of it on Lawfare. All right, exactly. we're gonna go to audience questions. The Q&A box is now officially closed. That is, if you add a question to it now, I'm going to ignore it, because otherwise these things never end. We're going to start with anonymous attendee. can federal court judges theoretically recuse themselves on the basis of being relatively new and not having handled huge trials before? The answer is yes, but the key word there is theoretically. They don't and they won't. And there's actually a strongly, jokes aside, there's it is genuinely disfavored to recuse yourself when recusal is not required. If you are not required not to hear a case, you are expected to hear it. Tracy asks, what do you make of Judge Chutkin's remarks about the trial being impacted if Trump's remarks could tamper with the jury pool? Sarafin, what did she say, and what do we make of it?
She didn't go into detail about that, but in my knowledge, if the jury pool is tampered with at the initial stages when jury is being selected, then it could discredit potential jurors who would otherwise be jurors in this case. And I suppose there could also be a retrial if jurors are tampered with over the course of litigation. I might actually punt the question off to Natalie because I think she'd be better suited to answer what happens in the middle of litigation if that were to happen.
Yeah, I think the biggest concern is what it might do on appeal if a conviction would be overturned on a number of grounds, which ground would depend on the facts and how the jury came out. Obviously, the government can't appeal an acquittal because that would violate double jeopardy. But if there are other procedural things that happen that suggest some sort of tampering with the jury that affected the outcome of the trial or the integrity of the proceedings, there are a variety of different procedural mechanisms that the parties can use to try to deal with that prior to a verdict. It's a little bit hard to talk about in the abstract. I don't know if others have thoughts.
All right, Keith, you have the next question.
Yeah, so I was wondering, it seems we've heard very little about Secret Service involvement. It seems like they'd be prime witnesses for the document case, if not January 6th, if not, culpable. So I'm wondering
Yeah, so I can take this one because I am old enough to have covered Ken Starr's use of Secret Service witnesses in the Monica Lewinsky case and the litigation that engendered. There is almost certainly Secret Service witnesses that are going to be that have contributed to these grand jury investigations and conceivably that could be called at trial. The Secret Service as an institution, and I just want to say, as they are the people who protect me when I project against Russian embassy facilities. So I love the Secret Service. And I feel a certain warmth toward them, really. I'm not joking. They are institutionally very reticent about ever talking about what is called their protective function. And that is confidences that arise. During the Starr investigation, they actually litigated the position that there was a privilege that protected against Secret Service agents being compelled to testify against those who they were about matters that they learned in their protective function. They lost that. And so the fact that the Secret Service witnesses were available to the January 6th committee, available to these grand juries, actually owes a debt to the Ken Starr investigation. They will, I suspect Jack Smith will avoid calling them at trial if he can, not because there's anything improper about it, just because it is an institution that really has good reason to not want to testify against presidents. That said, there are circumstances, for example, where the president is being driven from the rally to the White House, where the only people who may be privy to what he said and did are Secret Service agents. And in those circumstances, yeah, they can be brought to testify. I think it's going to be less of an issue with respect to Mar-a-Lago, because Mar-a-Lago, the material was not protected by the Secret Service, and the indictment actually specifically says that. So you may have Secret Service witnesses there to say, we had nothing to do with this. We weren't there to protect classified information. John, the floor is yours.
Thank you. Two quick questions. The first is it possible, or is it expected, that the January 6th unindicted co-conspirators may at some point actually become indicted? And if so, how do you think that might change the defense strategy that you've seen so far? The second question is, what do we know about the Arizona Attorney General looking into their moves to investigate false electors, and perhaps any other moves in other states, Wisconsin, Pennsylvania, et cetera?
All right. So Scott or Natalie, do you want to take the first question, indicting unindicted co-conspirators?
Yeah, happy to. I mean, I fully expect to see those indictments, and I expect to see them soon. I don't know in what order or what sequence we're going to get. It's possible some of them might still end up be cooperating or pleading out. It's possible there might be other intervening factors, but they have all of them in the indictment clearly alleged to engage in criminal activity, including the conspiracy, but actively engaged in the criminal conspiracy in various respects. They get a lot of screen time, if you will, in the indictment. Particularly you see John Eastman and Jeffrey Clark both making statements alluding to a willingness to accept violence resulting from the scheme that they're executing, which is significant for their states of mind and their understanding of the scheme. And it's something I think you put in there, both because it reflects on former President Trump, but it's hard to put in there and then not treat them as pretty culpable members of that effort. We know John Eastman expects to be tried because he tried to postpone his bar disqualification proceedings this week because he says he's facing impending criminal trials. And my understanding is, I believe the bar said, no, you should have been expecting impending criminal trial charges for a while now. So this doesn't actually
hire
change
more
anything.
lawyers, dude.
Yeah, hire more lawyers, exactly. So yeah, I fully expect to see those as soon as next week.
So I'll just add quickly to that. I think it is entirely plausible that we will see some of them. I am confident that for at least some of them, there are ongoing conversations trying to convince the unindicted co-conspirator or conspirators to cooperate against Trump, as Scott was alluding to. I think there's also a strategic question on the part of the special counsel as to when and how to indict people who are perhaps dragging their feet about whether they will cooperate or have already decided not to cooperate. And they can't hold on to indictments forever, obviously, but there is a question as to sequencing, because I actually looked into this. I was curious whether there would be any mechanism by which one of the many delay tactics that I expect the Trump team to use, whether they might say, okay, well, this other person was just indicted in this other proceeding, assuming that it was brought in a different proceeding rather than as a co-defendant, as was the case in the Mar-a-Lago case. So I want to file a motion to sort of consolidate these cases. There is a motion to sever cases when there are multiple co-defendants. From the folks that I spoke with, nobody is aware of there being a similar mechanism for consolidating defendants who are alleged to have engaged in the same sorts of conduct. But it is a thing that could be leveraged as a delay tactic. It's just another one of the ways that the facts around these cases are going to interact with each other and create additional strategic options.
Quinta, do you have thoughts on the Arizona question that John posed?
Sure. So I will confess I haven't been following the Arizona specifically, but it's worth noting that we've already seen this come to fruition in one swing state, that being Michigan, which we should hopefully have a Lawfare podcast episode about out next week. I just recorded it this morning with Clara Hendrickson, who's a politics reporter for the Detroit Free Press and has really been covering this story since the very beginning. So Michigan Attorney General Dana Nessel in recent weeks indicted the 16 fake Trump electors for their efforts to put forward a fake slate. And there was also a separate indictment, this one by a special prosecutor, of a handful of people for tampering with election machines in Michigan. So I think that the Georgia investigation by Fani Willis has kind of gotten the majority of the national press coverage. But clearly this is very much moving forward on the state level, and we've already seen it happen in Michigan.
Yeah, and Debbie points out that a civil case relating to against the fraudulent electors in Wisconsin just moved forward and will go to trial in September of this year. Thank you, Debbie, for pointing that out. And yeah, I think one of the interesting factors that's going on now is that there is accountability that is reaching down to the level of the individual fake electors and operatives. And that's something that I think 6 months ago, a lot of people really doubted was going to happen. Okay, Ken, the floor is yours. Ken, you've got to unmute yourself. All right, Ken does not seem to be unmuting himself. So we'll go to Michael. Ken, if you have second thoughts about that, we'll come to you next. Oh, Ken is unmuted. Ken, the floor is yours.
Sorry about that. I'm wondering about a scenario in which Georgia might indict but not seek extradition or arraignment. The Georgia statute of limitations on crimes doesn't run when a defendant is out of the state. And so they could announce that he's free to campaign in any of the other 49 states, but if he sets foot in the swing state of Georgia, he'd be subject to arrest. And they could wait till after the election. They'll probably have to wait out till after the election anyway, with 3 other jurisdictions ahead of them. Wondering about that scenario.
Okay, so thank you. I will take this one myself. I think that scenario is very unlikely. If you are Fani Willis and you have put your entire career on the line over this case, I think you're most unlikely not to then litigate it aggressively. I also think that you want as few variables as possible. And if you have not sought his voluntary surrender, realistically, you're not going to be dealing with an arrest or an extradition. You're actually going to be dealing with his getting on his plane and flying to Atlanta. If you're going to go through the exercise of indicting him, you're going to want him to be arraigned, and you're going to want to start that process of pretrial litigation.
Yeah, and I'll just add as a legal matter, I do not know Georgia state law, but I would be very, very surprised if there were not a criminal procedural rule that required a limit on the amount of time between indictment and arraignment.
And Debbie corrects me, the civil trial in Wisconsin is scheduled for September of 2024, not September of this year. Thank you. Okay, Michael, we're going to give your question one more try. The floor is yours. All right, I guess we're going to go to Jesse. Jesse, the floor is yours.
Thank you, Ben. Accepted wisdom seems to be that no judge will hold Trump in pretrial detention. 2 questions. 1, if he and his team know this, then what can any judge do to compel compliance with any court order? And 2, many things are impossible right up until they happen, such as criminal indictment or double impeachment of a president. What would be the consequence if one of these judges does decide to hold Trump in pretrial detention? Thank you.
All right, who has reckless speculation on this question? All right, I always can count on Scott for
Yeah, I
reckless
love it.
speculation.
I had started
live for
talking,
it.
but I had accidentally muted myself. Can I go first, Scott?
Yeah, Scott,
Sure, go for it.
Natalie's going first. I promise you Natalie's speculation will be less reckless than Scott's.
Mine is not actually going to speculate. Mine is just to say that this was actually something that I found so interesting about the scenario that Seraphine was pointing to and had found notable as well, which was the discussion of the contempt trap. So typically, if, as folks know, if a defendant just disregards the order of a court, there is the option for the judge to hold that person in contempt or to issue a bench warrant. I thought it was really interesting that it seems that Trump's attorney raised this issue of contempt on his own, and sort of seemed to point to, yes, I see that there is this mechanism by which you would enforce your orders. I'm worried about getting my client into trouble there, and I'm going to, use that as a way to push back against your order. But my guess is that the attorneys, as much as the judge, are really wary of the scenario in which the judge is forced to use her powers of enforcement and Trump just disregards them. And there has to be a literal standoff between a former president who has the platform of a political campaign and all of the followers that he has on social media and so on, versus the normal functioning of a courtroom. I think that really no one involved, except perhaps Trump himself, has any interest in seeing that sort of standoff, as much as we may all expect it to be happening.
Scott?
Yeah, I don't disagree with that. But I also think we have to be a little realistic about the dynamics around this. Like anything that actually substantively interferes with Trump's ability to campaign is going to have political ramifications and ramifications that echo in First Amendment protected speech, not just as the courts have kind of conceived it, Trump's First Amendment protected speech, but actually like the First Amendment protected speech of the people who support him politically and would vote for him and want to vote for him and are voting for him. I think the further you are from the actual presidential election, the little more attenuated that is. It's all kind of on a spectrum. It's a lot of factors, but he's the freaking leading candidate for the Republican nomination for the presidency, right? Like, it's not that attenuated. It's not that light a consideration like it were if you were like, one of 20 city council members or potential city council candidates. So, that's going to weigh really heavily. I think it's going to make that there's a reason why that's an unlikely scenario, honestly, is because the courts aren't going to want to tread too closely to that. If they are going to take that step, what they're going to do is they're going to say, Mr. President, you are barred from doing this once. Mr. President, very specifically, you can't do this. And if he does it again, then they will start sanctioning him. And they're probably going to start with, I believe they can just do financial sanctions initially before kind of restricting him through imprison or bring actual more harsh contempt measures. And I suspect you'll see those first. If they're not effective and the bad behavior continues, then you could get to a point where a court is compelled to do that. But it's going to be a ways down the line. And my suspicion is that any court that tries to do that is going to try and narrow it as closely as possible to clearly prohibited conduct that Mr. Trump has ignored warnings on multiple times, and that has a clear nexus to the security of the proceedings and the court matter. So you're going to see a lot of warning signs before you get there. Doesn't mean we won't, because Donald Trump is Donald Trump. I mean, he's already said, I will not be restrained. I have First Amendment rights and I intend to fully exercise them no matter what Judge Chutkin says. A shot across the bow around this whole issue set. But I think that scenario is still pretty unlikely because I think in the end, that's a scenario where Trump will look so obstinate doing something so outlandish to actually warrant that sort of response that it's not going to be helpful for him politically, and his lawyers will be strongly counseling him not to do that, and it will cost him a lot of money in the interim. But it's not impossible.
Yeah, I agree that it is the premise of the question, to the extent that conventional wisdom is that it can't happen, conventional wisdom is wrong. It can't happen without a bunch of preparatory steps, the earliest one of which you saw today, which is Judge Chutkin talking about how the order, the conditions of pretrial release are important and that it's important to protect witnesses. And, you're going to see a lot of patience, but I don't think the amount of lead leash is unlimited here. All right, we have one more question. We're going to get through it. Since we have trouble hearing Michael Gray, I'm just going to read the question. Please describe the detailed steps needed to recreate a SCIF in Florida and the cost to the US government. I can actually do this. I can't describe, the cost is a lot. A SCIF is an expensive piece of equipment, but the reason I can tell you what a SCIF is like is that Brookings is next door to the Australian Embassy, and the Australian Embassy recently was completely gutted in order to rebuild. And when they gutted the Australian Embassy, the SCIF that was on the 4th floor or the 5th floor, which I've actually been in, I briefed some people in that SCIF once, you could see the SCIF through the destroyed frame of the building. And it was a big steel box, basically, with a door that closed. And, you know, you could walk down the street and you'd be like, there's the SCIF in the Australian Embassy. A SCIF is a serious piece of equipment. It's basically a room that is made entirely of material that you cannot broadcast telecommunication signal through. So if you're sitting in a SCIF and the door closes, your phone will go dead. Any radio that you have will not work. And so it is a piece of equipment that is sophisticated enough to block all signal in and out. By the way, not just trivial signal like your cell phone, but you know, microwave beams and stuff that sophisticated intelligence services use to try to collect. So I don't know the exact cost of reinstalling one in Mar-a-Lago. It is significant. And it is maybe less significant because probably some of the equipment is already there from it having been there once before. And so Scott's joking correction of me earlier is actually an important point to this question. Like, it may be that it's not a big deal to put a SCIF in Mar-a-Lago now because it had one before, and so the basic stuff is already there. But I do think the government will resist it because it does have the quality of asking to commit the same activity that constitutes the crime that is now being tried. So yeah, that's you can no longer see the SCIF in the new snazzy new Australian Embassy because they now have walls again. All right, that is it, folks. We went 90 minutes this time. I have no idea how long these things are going to go in the future, but this seemed like a good length. We discussed all the events of the week. We took questions. For those who are joining on Zoom, join us. For those who are joining on YouTube, join us on Zoom the next time so we can answer your questions. Become a material supporter of Lawfare at lawfaremedia.org/support. You become a material supporter, you get the Zoom link every week, you join us for Lawfare Live. It is good fun. As John just texted me, it's like some of you will get this joke, sober in lieu of fun. We will be back next week. I don't know, I think I'll be in Iceland or Oslo or somewhere making trouble for the Russians, but I will join in the middle of the night. And until then, have a